partner in the matter of Dodd and others and commissioners for His Majesty's Revenue Enforcement.
Yes, Mr. Baldry.
May I first just clarify one point arising from the exchange I had with Sir Launcelot Henderson yesterday, which arose from reading the transcript. It appeared that one of the points Sir Launcelot put was that, or may have assumed, that SCL had paid tax and the revenue had received tax of the 28 from the revenue. And then the revenue under their Section 850 argument was seeking the same tax from the individuals. Of course, if the revenues argument on Section 850 is right, the effect is that the profits are reallocated from SCL to the individuals. So the awards that were allocated to SCL, by which time they had all been subdivided up so that they were earmarked for the individuals, those awards are reallocated. And that's all done in the partnership closure notice. The partnership submits its return to the revenue, which sets out in a statement the partners' individual profit shares. And that forms the basis for their individual tax returns or their corporate tax returns. And so originally on the partnership return, the profits which were allocated under the deed to SCL would have been recorded as SCL's profits, but the effect of the revenue closure notice is to reallocate those to the individuals. So
does that mean that HMRC has to serve a separate closure notice on the partnership? And if so, has it done it?
It has effectively the PIP appeals concern a closure notice on the partnership,
right?
And that's the sort of core document that the revenue needs to amend, and it has done that, and that's what the PIP appeal is again. So it's the reallocation. We'll come back to it in more detail. I just want to clear that as a
yes, thank you. I was not clear about that in my own mind. I mean, I thought, at any rate, there was at least a possibility of one ending up with a case of economic double taxation, which would be very hard to justify.
No, on Section 850.
On Section 850.
It's clear that what the revenue is seeking to do is tax the profit shares, but in the right hands of the right partners as the revenue see it.
Yes. A sort of related point that's worrying me, and perhaps I can put it to you now as well as at any time, is, I mean, supposing, obviously the LLP, the partnership, has to get its accounts audited in the usual way, and the accountants presumably have to show a true and fair view. Now, surely when an auditor is tracing what has happened to the profits, he'll look at the fact they've been distributed between the members, including the corporate member. End of story, isn't it? Well, why not? I mean, how do you get around that aspect of the problem?
Well, I think because for tax purposes, what the tax legislation is seeking to...
This is a tax adjustment.
The profits are the profits as computed for tax purposes, and then the allocation of those notional profits is allocated to the partners by reference to their share in the partnership, which is simply used as the measuring yardstick to work out what share of those notional profits for the year of assessment are properly taxable in the hands of each partner. As we've said in our skeleton, it's not that the tax legislation doesn't focus on receipts, it's simply a share of the profits. Although in this case, as in many others these days, the way that you work out the share of the profit is by looking at discretionary allocations, which are actually payments, involve payments out to the partners. But that's just the measure. So we would say that what the accounts say should not alter the process that needs to go on under Section 850. So what I was proposing to do this morning was take you to the allocation provisions in the LLPD and then go to the FTT decision just to see how the allocations worked in practice before and after the PIP, and then take you to the documents such as the forfeiture provisions, so you can see how the PIPs have worked in practice. And in supplementary bundle 1 is the limited partnership deed, which we looked at yesterday. So if I can take you back to that, it's at tab 7.
This is the deed at tab 7, yeah?
Yes, and you probably picked this up, but there are certain, there's underlining in this deed, and that's because it's the deed which was entered into on the 30th of April 2008, which was just when SCL joined the partnership, and the deed was amended as underlined, double underlined in this version, to introduce all the particular measures that are necessary for that purpose. So if I go to clause 12, which deals with allocation, on page 49 of the bundle. Just so that we understand the timing of the deed before we look at what happened in practice. Under 12.1a, it says that the profits of the partnership before tax, as shown by the accounts of the partnership prepared in accordance with clause 17, shall, subject as provided in this clause, be allocated amongst the partners as follows. And then we have allocations to the general partner. And we are concerned with 12.1.2. Secondly, they should be allocated to such of the partners, if any, as the general partnership in its absolute discretion determine such amount of profits in aggregate not exceeding the performance fees received by the profit in the relevant year, as the general partner shall, in its absolute discretion by resolution of the board of directors, determine. And then, in order to recognise investment performance attributable to such partners during the relevant year, has been deleted because prior to the PIP being introduced, the allocations under 12A12 would have been made to the individual members in recognising their investment performance. But that was amended to enable allocations to be made to SCL. And so, as I mentioned yesterday, the performance fees were sort of crystallised when the funds crystallised at the year end, the 31st of December, for the periods in question. But the final allocations under 12A would only be made once the accounts of the partnership had been drawn up. So the partnership changed its accounting year end during this period. For the first 2 periods, the accounting year end was the 30th of November, so that the performance fees were crystallised sort of early in the subsequent year, whereas for the later years, from 2010 onwards, the accounting period ended in 31st of December, so it took a little bit longer to work out what the performance fees for that particular year were. But for the 2010 onwards, as we'll see, that by and large the accounts were signed off and the allocations were made in September of the following year. So the funds were crystallised at an early stage, and Drawings were then taken up by the individual partners typically before the PIP was introduced, and the funds were, and the drawings were based on provisional calculations of the individual's total rewards for that year, and then they were not finally allocated until September. We'll have a look at the chronology from one of the charts and tables that's produced by the FTT. So on allocation then, under 12, the effect was that the amounts allocated to the partners would be credited to their distributions account. That took place under clause 13 on page 55. So 13.1 says each partner will have a capital contribution account and a distribution account. And the new addition, any partner has contributed special capital, and any partner to whom the special capital is reallocated shall have a special capital account, which operated in accordance with the provisions of clause 9 that we looked at. And then 13.3 provides that profits allocated to the partners are to be credited to the partner's distribution account, and save as agreed, each partner shall be permitted to withdraw amounts standing to the credit of its distribution account from the date that such amounts are so credited. The manner before the PIP was introduced, the only way in which the profits were shared, we would say, between the partners was that there was an allocation of those profits, and the consequence of the allocation of the profits was that the profits would be credited to the distribution account from which they could be withdrawn. So if we can turn to see how those provisions operated in practice by looking at the first-tier tribunal's summary, that's core bundle 1. If I can pick it up at page 141 of the bundle. So at 259, paragraph 259, the tribunal summarises the position before the institution of the PIP, and he refers to the allocation waterfall in clause 12 and makes the point that the level of each partner's overall profit allocation was intended to reflect his or her contribution to the partnership. Profit allocations were drawn in cash. Partners would typically receive an advance drawing in anticipation of the profit allocation, which would typically be made around the time the partnership audited or completed. So advance drawings early in the year based on the partner's presumed profit allocation, and then a final confirmation only once the audit has been completed. And then Mr. Dodd explained the process by which the discretionary profit allocations were determined, depended on the type of partner of which the allocation was made. In the case of discretionary traders, their performance over the year was reviewed, generally by reference to their individual profit and loss on the portfolio they were managing. And the total monetary reward proposed for the traders would be calculated using a sort of standard methodology. And that basic system of calculating the individual's total monetary reward at the first stage of the cycle continued before and after the PIP was introduced. And before the PIP was introduced, the once at an early stage was January, February, after the funds had crystallised. So early in the year, this calculation was done. That enabled drawings to be taken out by the partners in a very precise way with the discretionary traders, because they were actually managing portfolios, so you could see their contribution, how much their funds had actually performed that contributed to the overall profit. But a more discretionary basis was adopted for the systematic traders who sort of produced the algorithms and models by which the trading would be done sort of automatically or under computer systems. And then there were the small amount of just administrative staff. But all those people were the subject of a process by which their individual contribution to the partnership was calculated and their total award was measured. And the tribunal notes at 264 that under that model, all the profits were distributed to the partners each year. And what BlueCrest wanted to do was to introduce some form of incentivization to the partners to incentivize them to stay within BlueCrest. So they approached their accountants who it was that proposed the PIP. See, at 268, they wanted to bring in some form of deferment measure. They approached Ernst & Young, who, as well, Justice Lewison were involved in the related structure of introducing a corporate member into the partnership, which we considered in the Cayman appeals. And so the proposal here for the PIP, described at 268, was introducing a corporate partner to essentially capitalise the income profits so that they could be paid in capital to the partners. And as explained at 272, quotes Mr. 273 over the page, Mr. Dodd explained the advantage of the tax advantage of the PIP. So in his evidence described at 273, Mr. Dodd for BlueCrest explained that the tax advantage would increase the pool of money which would be available for the partners. But Mr. Dodd also notes that to get that benefit, the partners were asked to wait and accept some risk. So then there is a helpful overview as to how the awards were dealt with following the PIP at page 301.
Page 301.
Paragraph 301 on page 155. So this looks at the year ended 31st of January, 31st of December 2012. So this is when, after the LLP had moved its accounting period to 31st December 2012. We have here the year begins at 1st of January. The funds crystallise on the same day that the period ends. That should be 31st of December 2012 in box 3. And that was the crystallisation of the performance fees, which enabled the total cash pool available for distribution through discretionary drawings by the partners.
Sorry, you said it should be 31st of December, should be 2011, shouldn't it?
No, this is the first of this is the year end for 31st December 2012. So it starts on the 1st of January 2020 12 on box 1. It just happens that this was the year that evidence was given in one of the witness statements.
All right, I'm still not clear why it's wrong. I mean, it says 1st of January, commencement of the financial year. That's right, isn't it?
Yes, 1st of January 2012 is correct. And
Yeah.
it should be 31st of December rather than 21st of December. That's my.
Oh, sorry, that one in box 3.
Yes.
Oh, yes, I'm bigger upon this. Yeah.
So the funds for that year crystallised on the last day, but on that day, the performance fees they may need to be precisely calculated, but they were fixed at that time.
Yep.
And so in January, even the same as before the PIP was introduced, in January the managers went through the process of working out the individual's total rewards, taking into account their contribution to the business. And then February, over the page, box 5, we had the same process that happened before. The P&L statements for the discretionary traders would be assessed. The details of proposed provisional total awards for the traders were passed to the PRSC. And then, now that the PIP has been introduced, the PRSC, that's the PIP recommendation subcommittee, reviewed the provisional total awards and decided how each individual partner's provisional total award should be split between the amount to be made available to the individual by way of discretionary drawing in anticipation of a discretionary profit allocation, and 2, the subject of a recommendation made by the committee to the corporate partner to make a provisional indicative award of special capital for the relevant individual partner. And that is broadly how it worked in 2012. We've seen in the earlier years it was much more flexible in that the individual partners were simply asked as to how much money they wanted to put through the PIP. Their total award was calculated, and there wasn't a fixed split of 1/3, 2/3, as happened in the later years, but the individuals were asked, well, this is your total award, as they called it, their bonus. How much do you want to take yourself, and how much do you want to invest in the PIP?
Just looking at the 5th bullet point in box 5 for the moment, which talks about deferral periods. The last sentence says the deferral periods range from 6 months to 3 years, could be staggered over a number of years, each deferral was subject to a separate provisional indicative award. So does that mean that the provisional award would say, you've done this and this in the current year, and we're proposing to allocate to you so much for year 1, so much for year 2, and so much for year 3? Is that how it worked?
It wasn't expressed in such terms. Well, I'll take you to the details, but the reason for the payment wasn't expressly put like that. What happened was that the process was that the individual awards for each person would be calculated. BlueCrest would make a recommendation to SCL that amount, the 2/3 split in 2012, would be the amount that would be the subject of a provisional award, and then SCL or Avon would write to the individual saying, it has been recommended that you shall receive a reward of this amount, subject to satisfying the forfeiture conditions. Mainly, you mustn't resign, you'll be fired.
And these deferral periods were tailor-made for each individual, were they, or are they in a document somewhere?
They're pretty much all standard form. So in the early years they were shorter. In the later years they got longer, from 6 months to up to 3 years. There was a slight amount of tailoring as between the in in some of the years between the discretionary traders and the systematic traders. I think the systematic traders' forfeiture periods were slightly longer, but subject to that variation, when you look at the documents, the documents are all sort of standard form documents that are
Right.
all that needs to be done is a name changed and the amount changed, and possibly the months or the years of the forfeiture. So that happened, this is all happening in February, April 2013. And so so at this early stage, once the total award has been made, the split has been calculated as the 2/3, then the committee writes to Avon, making recommendations regarding the quantum of provisional indicative awards and the deferral period, and then Avon first issues the indicative letters saying what, so that's at that time, April, the individuals are told what their presumptive award is, and the partnership tells the individual partners and the corporate partners what amounts they can take as discretionary drawings on account of their individual awards. And the discretionary drawings for the individuals were taken out and enjoyed by the individuals. The discretionary drawings from SCL were went straight back into the PIP. So SCL Avon borrows money from the partnership and puts them back into the partnership. In fact, it doesn't actually leave the partnership, we're just subject to payment instructions. But in theory, SCL is contributing that additional money to be held as special capital, but subject to the arrangements of the PIP. And then with the special capital sitting in BlueCrest in a special capital account, that, as we saw from the provisions dealing with special capital, BlueCrest then had the power to instruct nominees, fiduciaries, to invest that special capital for on behalf of the individual. So an investment letter would be sent out saying, please will you invest these amounts in these funds in an account in the name of the individual who had received the award. And so that all happened early on in the year, but then we had to wait until the accounts had been audited in order for the final allocations to be made under the deed, and we can see from for the year ended December 2012, the profit allocations were finally made in September 2013. So at that point in time, the board resolved to make an allocation of profits to special capital and to the individuals. And the individuals were then able to take any monies that they hadn't already taken out by drawings from their distribution account. The monies that were allocated to special capital were sitting in the special capital account prior to being reallocated to the individuals.
Were they allocated to special capital, or were they allocated to the corporate partner?
This under the what happened when the profit allocations were approved by the partnership board in September, that was simply a formal allocation under the terms of the deed, that these amounts would be allocated because those were the discretionary performance fee allocations that had to be made by the partnership. So what the deed entitled the board to do, and what it did was say, well, we are allocating profits of a fixed amount to Special Capital Limited and a fixed amount to the individuals.
Yes, so it was allocated to SCL, wasn't? You said it was allocated as special capital, but that's the next stage.
Exactly. So if I did, I apologise. The profits were allocated to SCL and the individuals, but at the time that the profits were allocated formally by the board to SCL, the awards for the individuals had already been calculated. The award letters had already been sent out to the individuals saying what their award was, and the special capital was itself sitting in as an investment or a number of investments held in accounts for the individuals.
But presumably the final numbers may have changed from the provisional numbers, so the amount of special capital that ended up being acquired, should we put it that way, may be higher.
Yes, yes. There was a provision. What happened in February was a provisional estimate of their awards and
presumably a conservative one.
Reasonably accurate, but yes, I tend to be on. That's probably a fair way of putting it. There were certainly awards that were increased over time. And not so at the 31st of December, it says the next box 7 that was September 2013. It's the deferral period for the relevant provisional indicative awards for that year. Well, the first one ended round about September 2013. So there may have been awards that have become final by then. Certainly in the earlier years, when the accounting year was 31st of November, the fees were crystallised on the 31st of December, very early on in the accounting year. The same process happened, and the traders' awards would all be calculated in December or in January, April, and if those awards were subject to 6-month provisions, it would actually get special capital would become complete before the profit allocations were made. So they'd actually get a sort of an advancement of their right to take money out of the partnership. That's it. If I can sort of take an example of just to show you that what letters were sent out and how this operated in practice. Before I do that, I'd just like to point out there is one other similar chart or sort of timetable that operated for one of the earlier years with an accounting period ending 31st of November. That's in supplemental bundle 1 at tab. If I can just show you this briefly. Supplemental bundle 1, tab 16. this shows the different timings that took place when there was a November year end. It's the same basic pattern, cycle as they call it, but everything is advanced because the calculations for the performance fees are being made early in the year of the accounting period, just because the BlueCrest earned the majority of its performance fees right at the beginning of that accounting period, because that's when the funds crystallised. So, but it was the same pattern at the end of January 2009. The profits were for each individual were calculated. That's 6. The difference was in the earlier years, as you'll see from tab 8 on page 193. February to April 2009, as soon as profit available for partner compensation are known, the partners were invited to express a preference in 2008-2009. All the 2/3 calculations are performed. So there was a choice as how much they chose to put their award they wished to put through the PIP. Otherwise, the cycle continued as before, although for most awards in that year, the vesting period, the crystallisation of the awards took place on the 1st of August 2000. So before the profit allocation would have been made, which you see in this cycle was March, box 13, was March, April 2010. That's when the accounts were finalised and the final profit allocations of the board. Before that time, many of the awards had crystallised, and so the partners were able to take out their awards as special capital, and then formally, subsequently, the profits which had been borrowed by Avon, SCL, contributed back into the partnership and used to fund those reallocations of special capital. It was sort of formally confirmed that SCL Avon needed a final profit allocation to make sure it wasn't insolvent.
Do you distinguish between the period when the individual partner had a choice and the period when there was no choice?
No, we say in substance it's the same. The partnership agreed that that would be a better way of doing it, putting 1/3, 2/3. It's in substance what is happening is the same thing, we would say.
Well, except in the early years, when the partner has a choice, presumably he or she can say, "Oh, I'll have all the money now, please."
No, their choice lies. Well, yes, they could. Yes, exactly. Yes, they.
So it's rather easier to see an entitlement if it lies within the gift of the partner to decide whether or not to participate in the PIP, because that partner could, if he or she wished, take the money in cash. Whereas when there's no choice, there may be a difference, but you don't distinguish between the two.
I accept it's easier. No, I do accept that it is easier to see. When we come to look at the cases, it's certainly easier to see in the former case where the partners are choosing that they are just sort of agreeing to park their income somewhere else, and so they are the person truly entitled to it. But I just say that is a clue to what is essentially happening when the system was sort of put on a more formal basis, and that there was a split by which the partnership agreed that they would do it by way of a more formal split. But we would say that when one looks at the what rights had been created and what obligations had been created at the time of the profit allocation, we say by that time the profit share, which was intended to be delivered to the individuals, had already been worked out and calculated, and that profit share had been divided, except on the key difference was that the terms were deferred.
Yeah.
So if they could have done it so that a partnership could say in its partnership deed, well, we will allocate profits to the partners A, B, and C, but an allocation of profits to C, half of that shall only be credited to his distribution account if he remains with the partnership for another 2 years. So that would be a sort of deferment method, but we still have to allocate those profits for tax purposes in accordance with how the partners have agreed to share the profits. The fact that the C did get his profits on some form of deferred terms doesn't prevent the court from thinking, well, the division of the profits that was made in that case should reflect the true division. So if I can take you to a document, it's relevant to say, I haven't taken you through our sort of formal grounds and the cases, but you will see that we do draw a distinction in our ground 4, which is our Rangers case, and it's our main ground is simply reading section 850 purposively. These the rights to share in the profits are to be looked at in the sense that I've been trying to say, that we look at the what rights the partners have under these arrangements at the time of allocation. Our Rangers case is a slightly broader proposition based on the Hadley principle my learned friend mentioned yesterday, was that actually if there are profits which an individual has earned through their personal exertions, it's ineffective for them to divert those profits to another person, and that section 850 should be construed in the light of that sort of underlying principle. But I'll pick up on that later on. But perhaps I'll show you an example of how how that cycle set out in the Ernst & Young paper actually worked. So, as I said, most of these documents are in sort of standard form, but we have lots and lots of documents there. It was not that easy to find one set that fully traced its way through, but I think of one at the beginning of tab 25 of Supplementary Funded 1. So what I'm seeking to do here is go through a complete set of the cycle with an individual, picking up the standard form documents on the way. So this example here is Mr. Shermat, who was a discretionary trader, and this is in January, 29th of January 2009. It's still called the Partner Savings Plan, and Mr. Shermat writes to Ms. Kerridge, who's the tax manager at BlueCrest. I accept to subscribe to the Partner Savings Plan. My bonus is £4298002. I would like to invest the bonus in the partner savings plan, and I would like to place the money in these funds. So that's because by 29th of January, his total award will be calculated, and he wants to put the entire amount in the plan. So on page 247, we have the instructions from BlueCrest to special capital of the 9th of April 2009, recommending that
I'm so sorry, which tab are we at?
tab
31.
31, page 247. So this is BlueCrest writing to, this is starting off the award process, and BlueCrest recommends to Special Capital Limited that provisional awards to reallocate amounts owing to the credited special capital account are made. So by that time, it can be presumed that Special Capital has taken advance drawing, borrowed money, which has been contributed as special capital. And then over the page, you'll see the individual's awards, including third of the way down, Mr. Shermatt. That's his, on the right-hand side is his total bonus. And the award that he has made is the 3094, which is essentially the bonus less the provision for corporation tax at 28%. So that's the recommendation. And then on page 252, at tab 35, we have the award letter. Standard, this is very much on standard form letters. The only thing that really changes with the amounts, and as we've seen, sometimes the dates of forfeiture change. So that tells Mr. Shermatt you've received the initial recommendation from BlueCrest, the reallocation from the special capital that we hold should be made to you on or after 1st of August 2009. So April, and he's been told that he will get the reallocation August 2009, but we will take this recommendation into account when exercising our discretion over the incentivisation pool. We're not bound by any such recommendations. We retain absolute discretion over the incentivisation pool. Then the forfeiture provisions, you will forfeit the right to be considered for such reallocation if on before the vesting date a notice of removal is served on you. There's a bad leaver provisions under clause 17. If the board receives a notice of resignation from you, or if you are become an outgoing partner, outgoing partners where if you become bankrupt or there's a composition of creditors, that sort of matter, other than in accordance with 18.1 death or permanent incapacity. So,
what gives rise to the potential for a notice of removal? Clause 17 of the document we've been looking at is all about accounts.
So that's the LLP agreement. So
that's a different agreement.
There's an example of the LLP agreement at tab 14.
14?
Tab 14, 17.
Convicted of criminal offence, regulatory breach. See something like that. Yeah, so these are all basically defaults by the member.
And then outgoing partners are clause 18. So bankruptcy,
Yeah.
death doesn't affect their award.
Yeah.
So back to so those were basically the forfeiture provisions. But what changed then was the date on which the forfeiture period ended. So here we've got the vesting date,
Yeah.
1st of August 2009.
Can I take a step back for a moment? Going back to what the FTT found, at 264, which you've shown us, the FTT said there were no provisions entitling BCM to defer payments, require partners to invest their own money, or claw back profit allocations after they had been made, for example, as a sanction for frequent poor performance. And then at 303, Mr. Dodd said that 16% of UK provisional awards have not been made final due to departures and or losses being incurred. But the letter you've just shown us doesn't contain anything about clawback if you've done very well in last year's fund and your fund has now bombed this year.
No, that's completely true. And we had a there was a reason for which led to the accountants being asked to consider, but obviously by the time that the accountants had advised on it, the scheme had been sort of considered more thoughtfully. In the end, we are left with an arrangement which isn't tailored to those particular type of things, but it's still, we've always accepted that there is a genuine deferral element to it, but on terms that were not sufficient to displace the real profit sharing arrangement.
So is this right? The way the scheme worked in practice was there were no provisions for clawback in the event of losses or poor performance during a deferral period. Is that right? No, Mr. Peacock disagrees.
Well, I mean, these under the terms of the awards, these are the provisions that these are the causes of forfeiture.
Well, I'm reluctant to interrupt, but it may help if one looks at 292 in the First-tier Tribunal.
292. Paragraph or page?
Paragraph.
Yes, well, I was interested in seeing these eligibility conditions. I mean, it's put in quotation marks, so it looks as though there ought to be a document, but maybe there isn't. Maybe it's just in these letters.
I think we are concerned with the awards that have been made.
Yeah.
But is the point being made that because it was discretionary, you could? Is the point being made at 292 that because it was discretionary, they were not actually restricted to these particular eligibility conditions?
Well, it certainly remains the case that they were. We've never challenged the fact that there was a discretion, and so that the individuals did not have an absolute right, but nevertheless they did have the rights to be considered fairly and non-capriciously, which we say are sufficient rights for this purpose.
Right. So what the letter you've just shown us is saying is not that you will get this money, but you will forfeit the right to be considered for such reallocation.
Yes.
And therefore, when the time came for the second recommendation to be made, it was at least possible for the recommendation either to be revoked, so to speak, not made, in the light of poor performance in the intervening period, or presumably reduced.
It remained a theoretical possibility, but there was no evidence of that happening. And can I say that paragraph 125 of the Upper Tribunal decision, the Upper Tribunal held that they found that the corporate partner had a contractual obligation to give effect to the expectations of the individuals, that they would receive their final award of special capital unless they failed to meet the eligibility
Here
criteria.
we've got that phrase again, but
Yeah.
I'm in the dark about what they were, unless they are what is in the letter you've just shown us.
Yeah. Well. Yeah, I mean, I think we would say that by the time the partnership got round to agreeing this system, effectively the only eligibility criteria that are set out are the ones in the letter.
Nevertheless, we have, though it's not recorded as a finding of fact, the reference at 303 to losses.
Yes, in the event, I don't think there is any award letter that was sent out.
Well, but perhaps my query is whether it needs to be reflected in an award letter because of the discretionary element.
Yeah. Well, we would say not. I mean, we would say that the Upper Tribunal. We did debate this before the Upper Tribunal, and the Upper Tribunal found that 71 7 that Mr. Page 248 of Core Bundle 1 Dodd confirmed in his evidence that although individual partners accepted, they could lose their awards if they did not comply with the terms of forfeiture. Their understanding was it would not be taken away in any other cases.
But what are the terms of forfeiture?
Well, the terms of forfeiture must be the terms of forfeiture which are expressed in the letter, and there's no sort of challenge to that. There's no appeal against respondent's notice in respect of any of the findings or conclusions drawn by the Upper Tribunal.
Lord, Malone is in slight danger of misleading the court because there was an example, at least one, before the first tier, an individual who suffered in effect a clawback. He was awarded a sum by way of a provisional award. He had poor performance in the following year, and that provisional award was not delivered in the amount in the provisional award. He ended up with some lesser amount. And if it helps my learned friend, it was a Mr. Moore. Well, he was a subject of evidence before the first tier tribunal.
There were examples of changes happening on a consensual basis. People would agree. So I don't know whether that was
no.
I'll have a check Mr. Moore's position.
Well, have we got some findings of fact about that?
Well, we say that the relevant findings that the court should be concerned with are the conclusions drawn by the Upper Tribunal, which 71.7 and 72.5 that the Upper Tribunal has accepted. This is the core reasoning of the Upper Tribunal, which has not been challenged by way of any respondent's notice. The Upper Tribunal accepted that in practice the corporate partner was bound to exercise its discretion unless the forfeiture conditions were satisfied. And in practice, we say that is what happened. So if there is an outlying case where some agreement may have been reached, that should not disturb the court finding. In the 99.9% of of the cases. These were the forfeiture provisions, and the only cases that were aware that forfeiture took place are the ones that have been considered, and where forfeiture has taken place before the profit allocation was made, the revenue haven't sought to reallocate those forfeitures. The key date, as we see it, is the date of allocation, and that if at that time the individual had forfeited their right to be considered for such reallocation, then the revenue have not included that as a right to share in the profits for that individual.
Yeah.
So in summary, we would say that the only relevant forfeiture rights are those set out in these documents, and it'd be strange if there were forfeiture rights. There are two types of forfeiture rights. A person reading this letter and receiving it would reasonably consider that he was available to be, he had a right to be considered for the reallocation, except in those three circumstances. So that was the provisional award, and then at page 256, next step, the PIP recommendation subcommittee meets and votes to recommend that Mr. Shermack be transferred special capital. So all the individuals are set out on page 261. And Mr. Shermack's award is now 3691884.
Yeah, so in the numbered paragraphs background, the forfeiture conditions are what was recommended, that is in what was in the letter you've shown us. And then para 4 says that the conditions have now been satisfied.
Yes. And following that recommendation, BlueCrest writes to Special Capital Limited on page 262. Following satisfaction of the conditions set out therein, i.e. in the deed, we recommend that you confirm the provisional indicative awards made in April 2009 set out below. And then the final aggregate award value of Mr. Shermack is put on page 263, third of the way down at 3691884. That gets confirmed by a letter from Special Capital to Mr. Shermack on 12th of October 2009. Which says, again, as second paragraph has stated, the potential award was subject to certain forfeiture provisions, and we confirm that potential award has not been forfeited under these rules. We have, well, it's as stated, I think that must be in the first paragraph, they're talking about their letter of 14th of April 2009. So as stated in that letter, we have received a final recommendation from the board to make an award to you. Having taken into consideration the final recommendation, we are delighted to confirm that we hereby make an unconditional award to you, a special capital equal to 3,691,884. The award will be satisfied to reflect the above. In fact, the incentivisation pool is held in the partnership by reallocation to the special capital BCM LP. As we've seen from the deed, the effect of the reallocation meant that at that time, the Shermat becomes absolutely entitled to the money. There is an additional amount there, and we think that is there was an increase in the amounts actually awarded to the individuals, because there had been a change this time from Special Capital Limited to Avon Limited when the awards, first provisional awards were made. Special Capital Limited was holding the special capital, and so anticipating paying corporation tax at 28%. By the time the awards were made, Avon had come onto the scene, and special capital had been transferred to Avon. Avon is therefore able to give a greater amount.
Yeah.
I think that is the explanation of the larger sum. So Mr. Sherbat actually ends up with about 86% of the total value of the bonus he was promised. If one thinks in terms of the timetable set out in the Ernst & Young cycle paper, Mr. Shermat knows in January he's going to get a bonus valued at 4.2 million. If he's awarded directly that, he'll pay income tax rate. At the time that the allocation is made, Mr. Shermat's already expressed his preference. He gets the award letter promising that bonus, less 28% in 6 months' time, the first stage, but he actually gets the reallocation in October, which is, in this case, before the partnership accounting period has ended, and well before the partnership would have made a final allocation of profit to him. Is there any sense, we would say, in which the money that sort of goes into the savings plan and comes out to him before the partnership makes its profit allocations isn't part of his profit share for that year? I mean, he's just got it. He's able to take money out of the partnership, in this case, before he would otherwise have got it by way of a crediting to his distribution account. But if it had been after the profit allocation decision, and so after, there just would have been a deferment from the time he could have taken the profits out from special capital account. But those are the ways in which the profits are being shared, we would say. One person that isn't sharing in the profits in any meaningful sense, we would say, is Special Capital Limited, whose role is simply to facilitate the scheme. Looked at broadly, we say that the introduction of the PIP doesn't reduce the individual's profit share for the year in question. Different terms are applied to it, but the individual's total award remains, in essence, the individual's total award, and that represents their share of the profits for that year. And at the time of the final allocation, the profits of the year have been allocated, the performance fees have been calculated for each individual party, their total awards have been calculated, and the partnership has decided on the amount to be awarded to each individual partner as a presumptive award. SCL and Avon has informed the individual partners of that fact. They've been recommended to receive specific amounts. That's described in the letters as a right to be considered, subject to satisfying the forfeiture provisions. And in some cases, the individuals would have satisfied the conditions and become absolutely entitled to the award before the allocation formally took place. So the statutory question is, who was the person with the right to share in the profits? Was it the company which had invested the profits for the sole purpose of reallocating them to the individual purposes and not for the company's benefit in any way? Or was it the individual partners to whom the profits are awarded? And we say the individual partners. So those were the papers. So if I can look at what the FTT and the Upper Tribunal concluded about that, and why we say they were wrong as a matter of law. The FTT I can deal with quite briefly, because the FTT decided that there was a case of the Court of Appeal at the time called Rossendale, which so lots of Henderson will be familiar with. At that time, Rossendale had fairly recently come out, and it was seized upon by my opponent in the FTT as saying, well, this shows that you can't take a Ramsey approach at all if what you're dealing with is a sort of technical term derived from another area of law. Rossendale, it was a concept of entitled possession, and that case was said to be authority for the proposition that the statutory concept in 850, right to share in profits, was a pure matter of partnership law, and therefore, if the partnership agreement said that the profits were allocated in a particular way, then that is the only thing that you could look at, and it wasn't appropriate to take a broader view, and the matter was determined exclusively by the partnership deed. Now, the Upper Tribunal said, well, that decision can't stand, because by the time he got to the Upper Tribunal, the Supreme Court had delivered its decision in Rossendale, and said, well, actually, even in a technical case such as they were dealing with in Rossendale, you were looking at a concept of land law, which on the face of it, to any landlord, does have a very clear meaning. They said, well, in this particular case, it is capable of bearing a different meaning. But I'll just show you the conclusions in Rossendale. I think that's Authorities Bundle 4. Tab 67. So this was a scheme to avoid sort of ratings, rates where the companies leased properties to companies which were then wound up. And the issue was whether the companies that were just purely inserted as sort of shells to be to occupy these unoccupied hereditaments were the owners of the hereditaments, and that turned on a very sort of precise statutory definition of owner, which was in the statute was a person with an entitlement to possession. And the Court of Appeal had said, well, as much as we don't much like this arrangement, if you have a statutory provision which speaks of an entitlement to possession, there's only so much that you can do with it as a matter of purposive construction. And ultimately, if the companies had introduced a company and had, as a matter of land law, created all the appropriate contractual documents to create an entitlement to possession as a matter of land law, and the court just couldn't step in and ignore that. And Rossendale is yet another case from the Supreme Court, which firmly emphasises that under what used to be called the new approach to statutory construction, the courts have real flexibility both in interpreting technical terms and in applying those terms to the legislation and construing it to the facts viewed realistically. So that in the decision of Lord Briggs and Lord Legatt, starting on page 1503, they review the authorities, restate the authorities. They note that those authorities were typically tax avoidance cases, but they make clear that at 17 they are sort of more broadly more broad application than that. So at 17, they make clear the facts have to be looked at in the round. Lord Steyn explained in Rebukian that it was formalistic insistence on examining steps in a composite scheme that allowed tax avoidance schemes to flourish. Sometimes looking at a composite scheme as a whole allows particular steps have no commercial purpose to be ignored. The requirement to look at the facts in the round is not limited to such cases. So the mere fact that there may be some commercial purpose in an arrangement, as there frequently is in tax-related arrangements, such as employee benefit trusts or other arrangements where the tax element is to provide a real incentive to the individuals because they are paying less tax. But the fact that there may be some commercial element doesn't stop you taking a realistic view of the facts. And they emphasise in that passage the now orthodox approach of taking a purposive view of the law. 47, they then apply that to this technical statutory provision, and they begin by acknowledging that there can be no doubt that the definition of the owner legitimate in section 65(1) of the 1988 Act as the person entitled to possession of it is to be interpreted as donating in a normal case the person who, as a matter of law of real property, has the immediate legal right to actual physical possession of the property. Then at 48, they say that in the unusual circumstance of this case, however, identifying the person entitled to possession in section 65(1) of the Act as the person with the immediate legal right to possession of the property would defeat the purpose of the legislation. As we've explained, the schemes were designed in such a way to ensure that the SPVs whose lease was granted had no real practical control over whether that property was occupied or not, and that such control remained as with the landlord. In our view, Parliament cannot sensibly take into intended that the person entitled to possession of an unoccupied property, when the liability for rates is imposed, should encompass a company which has no real or practical ability to exercise its legal right to possession, in which that legal right has been inferred for no purposes other than the avoidance of liability for rates. So even where you have a statute that is based on a technical term of art derived from another area of law, which has a very clear meaning, that one still has to look in each case as to whether that technical meaning is the meaning that Parliament has intended to be used in any particular case.
So they go on to say, don't they, in 49, Parliament can't sensibly be taken to have intended that a person entitled to possession of an occupied property, etc., should encompass a property which has no real or practical ability to exercise its legal right to possession, and on which that legal right has been conferred for no purpose other than avoidance of liability for rates. So that was a no purpose case, no business purpose.
But they said earlier that the fact that, that this approach isn't confined to cases where there is no commercial purpose.
Where just show us again where they say that.
About the reference to Scottish Providence.
Yes.
So it's where?
17.
17.
Yes.
Looking at so if you're applying a Magukian formalistic approach, you can take into account mostly in the past this has concerned schemes which allow steps which have no commercial purpose to be ignored, but the requirement to look at things in the round is not limited to such cases. So I think what the court is saying is that because it is now not a tax avoidance principle, it's just an ordinary principle of construction. One has to look at the facts in the round in any case to see what is happening, and the mere fact that there is a commercial purpose shouldn't disturb the real inquiry, which is to say, well, when Parliament is using a concept of entitlement, even a very narrow technical concept of entitlement, in any particular case, is that, are they talking about a pure legal entitlement or an entitlement which confers some sort of practical and real entitlement? And that's with a very, very sort of technical provision. I mean, here, I would say that the statute here we're construing is simply a statute that talks about the right to share in profits, and those are not sort of terms of art as such. We're looking at who is the partner with the right to share in the profits, and sharing means, you know, properly sharing and beneficially, not just simply taking one's part in a scheme. And so,
doesn't the concept of a right entail a legal entitlement of some kind?
But I would say that it strictly does, but the precise nature of that entitlement is left open to interpretation. So if one's got, as in the present case, competing candidates for who has the right to share in the profits, then if someone has a pure legal right that is fettered by all sorts of constraints as what they can do with it, and another person has the real and practical right to enjoy the profits, looked at the scheme in the round, then the person with the right to share in the profits is properly to be regarded as, in this case, as the individual partners.
So essentially what you're saying, I think, is that on the making of a provisional award, the person to whom the provisional award is made has a conditional right to the award, and satisfaction of the conditions sufficient to qualify for the final award is entirely within his control.
And that right is a greater right than any right held by the company.
Yeah. Because if he ceases to work for reasons beyond his control, such as death, he doesn't forfeit his right. It's either it's default of some kind, which causes him to be expelled, or he resigns.
Yes, that's essentially.
So
what it's saying.
satisfaction of the conditions, you say, is within his gift.
It is within his gift, and one is not even concerned with looking at his immediate entitlement to payment, because what one's essentially concerned with how's the partnership decided to divide the profits at the time.
Can you help me on one aspect which I always find troubling in these cases, which is like what the courts are driving at when they enjoin us, as we obviously must, to take a realistic view of the facts. What does realistic mean in this context?
It means
Other than a sort of metaphorical, nebulous concept of just the one which is going to produce a result which leads to the revenue winning.
well, it's always relating to the statutory phrase. So
If the
well,
statute
or-
is framed in terms of a right, you know,
yes.
how much wriggle room does that one give one? I mean, that is where the analogy with Rosendale perhaps
Well, in Rossendale,
comes in,
it was
although it was a
well,
very
it was
different case.
entitlement.
It was an entitlement. But to a property lawyer, the answer was obvious. Once you had a lease which was agreed on all sides not to be sham, that's very important,
Yes,
then it conferred a legal entitlement to possession.
yes.
And the parliamentary draftsman has used that phrase.
There,
The
yes.
job of the court is to do what Parliament says,
Yeah,
not to invent a purpose which one can't find
But
anywhere else.
I think that there was and the Supreme Court made clear that you know, in most cases that would be the case. But it's a bit like the
Well, this case was different.
the shares in Arrowtown.
Yeah.
You know, the company issued unusual B shares that any company lawyer would have said was issued share capital, but as it was, those shares were just issued for the purpose of getting into some relief. They were not regarded as issued share capital. So there is a final test that even with a very strict legal concept that's being engaged, the courts are entitled to ask themselves, well, in applying that concept to these facts, does that Parliament intend this to happen? And sometimes the answer would be clear.
Well, I mean, there used to be a theory that taxation had to be imposed by clear words, but now we have something that looks much more like taxation by metaphor.
Well, I think the words of Parliament is always about the interpretation.
Yeah. And of course we have to look at the thing in the round and so forth, but it's very important also not to adopt a question-begging definition of the purpose, which will lead you to the conclusion you want.
And I can see that in some cases that the court may again be faced with a very, very clear legal concept, which is being sort of used in an unusual case. But say what this case doesn't raise that sort of nicety, because although Parliament does talk about the right to share in profits, that is just we're looking at sharing. So who is actually entitled in some way that is legally enforceable in some way to share in the profits? And
You
that's
might
still
think then that your first port of call should be look at the partnership's accounts, where you will see the profits being divided up, you know, between the individual members and the corporate member. Nobody's suggesting that is sham, that the corporate member, I think, doesn't, you know, nobody's saying it doesn't actually have any legal right to the profits which are allocated to it. It's just very much trammeled as to what it then has to do with them.
Yeah.
But how can that affect the actual right to the profits?
Because if the we would say if the it's not a gap-based test where the answer follows the accounts. There's nothing that says that ties Section 850 to the accounts expressly. The accounts are evidence, like any other piece of evidence, but they don't. If you know, in a clear case, if there was just a straightforward two partners, and they agree to share the profits 50-50, but in 1 year, an individual partner had massive losses for tax purposes, and they just said, well, this year we'll make a discretionary allocation of profits to partner A with his losses, and partner A agrees that he'll pay those profits on to partner B, then the accounts may show partner A got the formal allocation, but for tax purposes, one has to look at who had the right to share the profits, and in that case, if there had been a side agreement outside the partnership, but to say A promised to pay, legally promised to pay, so we don't have any of our sort of conditionality, we could say that for tax purposes, the person with the right to share in those profits is the person who it was agreed would get the profits and enjoy them.
Thank you.
So if I just say where the Upper Tribunal erred in law, it's we say that the Upper Tribunal got in terms of its interpretation of the arrangements, got a long way down the line and reached conclusions which should have led it to conclude in the revenue's favour.
You would say they really lost the courage of their convictions at the critical point, but having started off in the right direction, they didn't go
They put all the groundwork in paragraphs 70
Yes.
and 71 of making it absolutely clear that the corporate partner was completely fettered in its role, and it was bound to exercise its discretion. But then they still concluded that at the time of the profits were allocated, the individual partner had no right to share in partnerships, and the individuals only had a right or entitlement to receive their awards once they were entitled to withdraw the special capital. And so we say that that was a wrong conclusion. We say that having all the conclusions that they had in 71 and 72, including they'd accepted our Braganza point, and
sorry, just on that, they say the corporate partner had in most cases a contractual obligation to give effect to those expectations. That is a reference to Braganza, but I'm trying to understand
so is that
exactly how far that goes. The fourth and fifth line of third and fourth line of 72. You're saying the submissions on Braganza were accepted, and that is the acceptance of it.
yes? Well, at three they expressly say that it was an implied term of the
Yes, but that's expressed slightly differently to the opening words in 72.
Yes,
That presumably is because you can comply with the Braganza obligation, exercise your discretion rationally, and not award the bonus. Not necessarily in this case, but in many of the bonus cases where people complain they haven't been considered properly for the bonus, it will be open to the employer to say, well, I did consider you, honestly and in good faith, with no ulterior purpose, and I decided for good business reasons you weren't going to get a bonus this year.
And also the Upper Tribunal also accepted that both at 5, the Upper Tribunal both on 249 they accepted in practice the corporate partner was bound to exercise its discretion to give effect to the PIP awards unless the forfeiture conditions were satisfied. Moreover, the evidence before the FTT established that in practice reallocations were made in accordance with the recommendations made to the corporate partner, except in a few cases where a mistake had been made or there was good reason for departing from the recommendation. I think there was evidence given by Avon saying that there had been a couple of times where the final recommendation was lower than the earlier recommendation. So Avon saw its role was to ensure that the provisional recommendation was maintained. If it looked like something had gone wrong.
But if there's a good reason for departing from the recommendation, then you would satisfy the Braganza term.
Yes, but the Braganza right does. It's not, given that there is this obligation, which is an enforceable in a court. The individuals can go to court and seek to enforce a Braganza type obligation, and it's been confirmed in the Reinhardt and Ondra case that's in the authorities that can happen with a member of an LLP. There was a discretionary bonus that the claimant was due to receive in that case, and he didn't receive. He received a lower sum. He got 50,000. So he brought a claim saying that that was an unreasonable exercise of the discretion, and the judge said, "Well, yes, on the face of it, it was, and damages were left to be considered elsewhere." So our members, with their letters and their clear terms of the circumstances in which they would lose their rights, do have enforceable rights, and one weighs those rights against the rights that the companies had, which was no right to enjoy the profits, save only for there's some evidence that Avon was an independent person. Because of that, there are even more fetters placed on Avon's discretion. But the 15% that Avon took was, looked like a fee. So to that extent, Avon had some entitlement, whereas SEL, we say, had no entitlement to anything. SEL was just a creature governed by a purpose trust, whose object was to carry out the award. So subject to the Avon's 15%, there saw no possibility of the companies enjoying the profits or sharing in the profits in any sense. But if we're right on our Rangers approach, then Avon's 15% is similarly disregarded, because that's just part of the total award that the individual members agreed, acquiesced in saying that Avon could have.
Sorry, I misunderstood. I thought you were not seeking to reallocate the 15%. In relation to Avon.
We have, the closure notice do reallocate the 15% to the individuals, but saying that's the only, that is the only circumstance where we could see that meaningfully the corporate partners having any sort of own enjoyment of profits.
So the closure notices reallocate the whole amount, but I understood that you were drawing a distinction in your skeleton argument.
Yes. Yes, in our skeleton argument we accept that the 15%, unlike any amount provided to SCL, looks rather like a fee that Avon got. Avon said, well, look, give us the the total profits, we will pay 85% as a reallocation of special capital. If Avon were able to arrange so that they paid less than 15%, then it didn't seem there was any way of ensuring that that would come back to the partnership. So Avon took out that 15%.
Where do we find any findings of fact to back up that analysis of it as a quasi-fee?
Well, I think Avon accepted it in the evidence. It may be in the transcript.
I thought the position was rather that it was regarded as analogous to the 28% which taken by SCM, which one can readily explain by reference to the rates of corporation tax. And then there were mysterious reasons, not vouchsafed, for in the hearing, or indeed on this appeal, as to how it was that Avon thought they could satisfy their corporation tax obligations by retaining only 15.
Yes, I think as far as the findings in the FTT are concerned, that probably is all that happened, and there probably was no real discussion about any difference between Avon and SCL. But
we can't begin making findings of fact in this court on the second appeal on questions of law.
That's true. Now, I'll put the evidence we say that showed Mr. Beverley's evidence, which is in the bundle, but there are no findings on it, accepted that essentially it was a fee. Mr. Beverley's evidence on page 563, day 11 of the FTT hearing, for paragraph 41.
Sorry, is that in the bundle?
Yes, it's page 563 of supplementary bundle 2.
563, yeah.
Yes, code 41 was a discussion concerning what the nature of Avon's allocations were. Well, it doesn't have much to it actually. They say that in loose terms, he says that line 13, they called it a fee.
So we did negotiate a fee. Right. Whose evidence is this?
Mr. Beverley, who is the director of Avon.
Sorry.
It's manuscript page 41, lines 21 to 22.
Read on to 42. Line 9 on 42.
Yes, and Mr. Beverley so he agreed it was a fee, but then he says it's wrong to call it a fee because it was still in the form of an excess profit. So in terms of terminology, maybe equivalent with the word fee, it was an excess of a profit over an obligation. He viewed it as an amount over and above anything they actually had to pay out, so there may be a fee element. But subject to that, the profits, which formally allocated were all destined to be used in the PIP. So going back to the upper tribunal, just to finish off. Just returning to the reasons, the three reasons that the upper tribunal gave. This is page 249 of Core Bundle 1. And so we say that, that the first reason was that Avon SEL did have a commercial function. They sort of solved a business issue. We say, okay, well that is a factor, but it's not a determining factor. And we say it's not relevant to the question about whether the deferred part of Mr. Platt's remuneration represents a right to share profit by him in the BlueCrest profits, or the right that's enjoyed by Avon. So that's one reason. The second reason is that the corporate partner was not intended to be a genuine partner. So it wasn't a sham argument that they were running. And of course, we accept a sham argument. The argument is much more an ordinary argument of trying to work out who had the right to share in these profits. So those two reasons we say don't answer the statutory question, and their sort of overall conclusion, that third conclusion, that the corporate partner had no right. Well, their question was if the corporate partner had no right to share in the profits and the individual had forfeited his or her rights, who was entitled to share them and on what basis? I think that's a question. I think, well, if one couldn't identify it, it has to fall back as being the corporate partners. But again, that's not analysing the nature of the rights enjoyed by either partner, and it's not sort of pressing home to its conclusion all the earlier reasons it had given before.
You have to somehow get over, don't you, clause 9.4a of the partnership deed, which says that monies standing to the credit of a special capital account shall be held exclusively for the benefit of the relevant partner, here the corporate partner, and only the relevant partner, here the corporate partner, shall be beneficially entitled to such monies. Now, if you can't say that's a sham, how do you get round it?
Well, I would say that you have to look at that when answering the question who has the right to the profits. But that's the sort of mechanism by which the profits were dealt with. But at the time the profits were divided, at that time, the partners had already had their presumptive share. So the amounts that were standing in the special capital had been earmarked for the individual partners, and the way that special capital or Avon would deal with that, those profits were had to be viewed in light of the arrangements as a whole. In fact, with Avon, the position was even clearer. I think Avon had undertaken not to take capital out of the special capital. It supplemented bundle 1, tab 45. This is SCL. There was no reasons to have any particular agreements with SCL because it was just a creature of BlueCrest. Avon was a separate company, so on the face of it, they had a right under the partnership deed. In practice, we say they had no practical entitlement to that deed because they needed it to fund their awards which they had committed themselves to make. But even so, Avon was required to agree not to withdraw special capital in the letter of 10th December 2009. Second page, first of the paragraph, ABM hereby agrees it shall not withdraw or reallocate all or part of the new special capital in accordance with 7.4b or c without the prior consent of the partnership. So one can understand that if one introduces a new commercial partner, no matter how much you may wish to trust them, and no matter how much you may think, well, they can't take that money because they promised it to the individuals. Nevertheless, Avon was required to say, well, I'm not taking that. So they didn't have an immediate entitlement to anything, and the partners had rights flowing from their awards to take them, to be awarded the special capital. So, looked at broadly as how this scheme was intended to operate. I would say the person with the true rights to enjoy the profits were the people that actually did enjoy the profits. In short, it's a right to forfeiture is still a right. Right, subject to forfeiture is still a right.
Yeah.
So, if I can sort of summarise our grounds, they're sort of set out in skeleton. We have put the case in alternative ways that we've been concentrating on the main first alternative, that reading section 850 purposively and applying it to the facts realistically, that the individual partners were the persons who were entitled to share the profits in the way explained. Our second ground was that even if, as a matter of ordinary construction, the court does not think that those sort of rights are the rights enjoyed by the individual partners. We say that's different, where the individuals actually received their final PIP awards, having satisfied the conditions, the forfeiture conditions, before the partnership made its final allocations. So that would be, this happened more in the earlier periods up until before 2009 and 2010, where it was fairly regular for the vesting date to happen before the final profit allocations were formally made by the partnership. In those circumstances, we would say that that's different, and those clearly did have rights.
So that applies to some, but not all. Is that right?
Yes, that would
So
apply to some.
Suppose we are against you on your first submission, but with you on this one. What do we do?
Well,
It has to go back to the FTT for some sort of recalculation of quantum, does it?
I would, if it cannot be agreed.
Yeah.
I mean, most of the documents are here. There has been reasonably good communication between the parties at agreeing things so far. But if it couldn't be agreed, then yes, it would have to be.
Right.
The third ground is that supposing that allocations notionally made to the corporate partners are to be accepted as valid and applying ordinary principles, is there any further principle that the revenue can rely on to say, well, actually, in the circumstances of this case, the amounts of profits which were essentially acquiesced to be transferred to the corporate partner should be disregarded, and we say yes, there is a wider principle engaged here, which flows from the reasoning of the Supreme Court in the Rangers Football Club case and the decision of the Privy Council in the New Zealand tax case of Hadley. Hadley was the case which a partner simply assigned. And Fred mentioned it yesterday. A partner, accounting firm, assigned his share of the profit to a trust, a family trust, and the New Zealand court said, well, that was just ineffective for tax purposes. That the tax charge in Hadley was a tax on earnings, and the New Zealand court's reasoning was that a person derives earnings or potential earnings from their own personal exertions, and that is their income, and that they can't alienate that income by simply transferring it away. That reasoning in that sort of partnership case was then applied by the Supreme Court in the Rangers case to employment income. So Rangers Authorities Bundle 3 tab 58. This was the case which considered the tax effects of companies transferring funds to employee benefit trusts for the benefit of their employees. The idea being that the employees would be able to enjoy distributions from the trust in a way that wasn't subject to the ordinary income tax charge, such as loans or possible subsequent payments out of the trust when you'd cease to be an employee, that sort of thing. And the case is authority for the proposition that where an individual has, by their personal efforts, earned some income as an employee, and they acquiesce to some arrangement whereby another person becomes entitled to those earnings, then they are taxable on those earnings, even though they don't receive them. And although it's a case on taxation of income by an employee, the reasoning, we say, applies in the same way to the taxation of income profits earned by partners. There's a crossover from the New Zealand reasoning to reasoning here, and there's likewise a crossing over from the reasoning here to partnerships generally. So if I take the judgment of Lord Hodge on page 1105, it says it's a tax avoidance scheme by which employers pay remuneration to their employees to an EBT, a trust, in the hope that the scheme would avoid liability of income tax, and raises a fundamental question about the nature of income tax charge and employment income. The question is whether an employment remuneration is taxable as his or her earnings when it's paid to a third party, in circumstances in which the employee had no prior entitlement to receive it himself or herself. So at page 1106, we have the basic tax charge on emoluments, which is just 5 taxes charged on emoluments from employment. And there were 2 types of employees which were relevant here. There were footballers who, when they signed for the club, there would be some sort of side letter to their contract explaining that the club would fund payments to the EBT. That's described at paragraphs of 20, 21. Paragraph 31, the court makes clear that the same trust mechanism was also used in paying discretionary bonuses to senior executives. That's 31, page 114, letter E. So there was a difference, because it's easier to see that the footballers who had this side letter, which was actually part of the terms on which they were engaged, had some form of entitlement to the earnings, whereas the senior managers were simply entitled to whatever discretionary bonus they were given, and so they had no prior entitlement. And the club adopted the same arrangements for both. And the question is whether the tax charge emoluments included some requirement that the employee should receive or be entitled to the emoluments. Lord Hodge puts that as the central issue in the appeal at paragraph 36 on page 1115. There was he turns to the legislation. So there's nothing on the face of the charge on emoluments which specifies that the employee had to receive or be entitled to the earnings. And Lord Hodge at paragraph 39 infers that he can't see anything in the wider purpose of the legislation which excludes from the tax charge or the PAYE regime remuneration which the employee is entitled to have paid to a third party. And we would say that where partners have agreed that an individual's total award should be transferred to a third party, and that award forms part of the individual's basis of his award because it's been calculated in his profit and loss, then it doesn't lose its character as the individual's profit if it's agreed to be allocated or paid to another person.
But you've got a deal, haven't you, with Lord Hodge's distinction between an immediate entitlement and a contingent entitlement, which is the third circumstance he refers to in paragraph 41, Roman 3, just above letter C, and which he then expands in paragraphs 47 and 48. And here, there is a contingency. You've called it a forfeiture, but it is nonetheless a contingency, isn't it? You don't actually get the money unless you satisfy the conditions.
Well, that's true. Those were all the sort of, various categories, but nevertheless, in the present case, when he was looking at the how to apply earnings to the two different categories of employee, there were the footballers who did have an entitlement, but it was subject to a contingency. And there were the managers who, at the time the monies were paid over to the EBT, didn't have an entitlement at all They simply had, it was their discretionary, what would have been discretionary bonuses, what would have been an entitlement had they received a discretionary bonus. That amount was paid over to the EBT.
But the point is, when allocation or payment was made to the EBT, there wasn't thereafter a contingency, was there, on the facts of the case?
Well, there was a discretion.
No, once paid into the EBT, it was held for their benefit. Weren't there sub-trusts?
There were sub-trusts, but nevertheless, the sub-trust, the trustees of the sub-trust still had discretion, and there was a risk that it wasn't guaranteed. It wasn't approached on the basis that the provisions of the trust were a sham. There was a risk that
the FTT found there was a real discretion to be exercised, and HMRC didn't challenge that.
yes.
But I mean,
So paragraph 65, that Lord Hodgson
65, did you say?
65. The conclusion
Yes.
was that there was a chance that there was a chance that the trustee might not give the loan that was expected, but that chance doesn't alter the nature of the payments to the trustee.
This case looks quite like Edwards and Roberts as described by Lord Hodge at 47, doesn't it?
You mean the present case? Well, I would say that because there is an element of conditionality, but that still did not deter Lord Hodge from concluding in relation to the managers who didn't have an entitlement and who were subject to contingencies, that the payments to the EBT was to be treated as their income. So 65.
Yes, but that is with reference to Scottish Providence,
Yeah.
and looking at how the plan was intended to work, rather than the possibility, contrary to the intention and expectations of the parties, it might not work out. The reference in Scottish Providence is to commercially irrelevant contingencies. Here, you have to deal with the fact that these contingencies are not, arguably not commercially irrelevant.
But I think they're back to
On the contrary, the Upper Tribunal found they were.
yeah. I think we're back to the question as well. When you're applying an approach of looking at the facts realistically, does the mere fact that you have some commercial purpose mean that you sort of take a different approach? And we certainly say no, that the fact that there is a commercial approach, as there were for many EBTs as a commercial approach, but if ultimately the conclusion here is that you do look at we would say you look at the facts in the round, and the fact that they've acknowledged that there was a discretion, acknowledged that the managers didn't have any entitlement to pay their discretionary bonus before it went into the trust. They were subject to a discretion when they were in the hands of the trustees, but nevertheless, the footballers and the managers had been prepared to take the risk that the scheme might not operate as planned. And here we saw the evidence that Mr. Dodd said that here the partners took the risk that their bonuses wouldn't be delivered, and they were prepared to take that risk. But the conclusion is that whether it's for the footballers with their side agreements or the executives, you have to look at the arrangement as a whole, and in particular you have to look at the arrangement in accordance with how it was intended to work. We would say that a similar approach can be taken here, just as in the managers who had their bonuses calculated. They must have been calculated because someone made the calculations before paying the amount to the EBT. That was a bonus that they had effectively earned by their work for the company. But they didn't have any entitlement to it, and it was put in a trust, but they were charged to income tax on it because that was how it was intended to work. So applying that reasoning to the present case, we would say that, well, here the individuals have provided their personal work to the partnership. Their share of the profits had been calculated in advance, and what they acquiesced to use Lord Hodges' words, was an arrangement by which their share would be enjoyed by somebody else. And the fact that there was a risk that they might not enjoy that share is something that it doesn't mean that you shouldn't apply the legislation to the arrangements as they were meant to, and it very, very largely did operate. So if there were some very sort of 2% in value of 2 to 3% in value of awards were forfeited, and probably about half of those were forfeited in the period before allocation. So we're talking about a de minimis amount of awards which in fact were forfeited. So that shows you how the scheme was intended to work, and it did work how it was intended to work.
Right, how are we doing for time, Mr. Baldry?
Well, not too bad, because I will be much shorter on section 687,
right.
And many of the points here are sort of relevant to the 687 analysis. So I will be no difficulty whatsoever in finishing today, and maybe I think Mr. Chacker is going to follow me on.
Yes.
Self-occupation income.
Yes.
He reckons about half an hour, 3/4 of an hour, so we're on track. I'm very near the end of 850, so I'll just finish off on the Rangers case. And it was just to note that in reaching this conclusion, Lord Hodge had referred to the Hadley case at paragraph 50 on page 1119, where he notes that the appeal concerned income tax legislation in New Zealand. Section 38(2) of the Income Tax Act provided that income tax was payable by every person on income derived by him during the year for which tax was payable. So that was the charge. And then notes over the page that the New Zealand courts had rejected the contention that he was not liable. Privy Council had held that income tax was a tax on income, which was the product of the taxpayer's personal exertion, and the taxpayer did not escape liability to pay that tax by assigning a part of his share in the partnership. And while the relevant provision of the New Zealand statute was worded differently, the UK statute adopts a similar process, similar concept. So the New Zealand case of the assignment of the partnership was used by Lord Hodge as by analogy with the charge on employment income, and what underlies the museum case is this concept that income, which is the product of a taxpayer's personal exertion, is something that's difficult to alienate for tax purposes. So that if in the present case there had been an assignment of a share from one partner to another person, that would be ineffective for tax purposes. And here, although there wasn't an express assignment, what there was similar to the Rangers situation, where the partners acquiesced. They were partners, they sort of agreed up to this PIP arrangement, and they acquiesced that part of their share should be enjoyed by another partner. Now, there will only be rare cases, I imagine, where this principle would work within a partnership. One can see it applying regularly to circumstances where people start to assign their income outside the partnership. Within a partnership, it would be more difficult. But in the present case, where you do actually have the partners themselves having measured and agreed the performance value of each individual partner's personal effort, that's their total award, and they take the decision, they acquiesce to part of that being transferred into the PIP, either in the early stages by the individual partners' positive decision, or by the fact they have acquiesced to the arrangement whereby the 2/3 would go into the PIP. In my submission, that is a background principle of income tax law, which you're entitled to have regard to when considering Section 850. And the effect would be if the principle is recognised for partnership law here, that a partner is not entitled to alienate their presumptive profit share in such a way, then the consequence would be that the entire amount of the award would be still remain part of the individual partner's profit share. So in practical terms, it's largely the same, but in the case of the Avon 15%, it would be different, because if the result is that the partner's presumptive share is their income, which they've derived from their personal efforts, and the tax code wishes them to pay tax on that income, then the amount that they transfer to another person, even if that person does enjoy the income, is ineffective. So in the Hadley case, the trustees were the people that were legally and beneficially entitled to the Mr. Hadley's profit share. But, for tax purposes, it was regarded as his. So the only difference, practical difference, would be in the present case, I think this is right, the 15% that on our 850 argument remains something that is appropriate to regard as a profit share enjoyed by Avon under the Rangers' approach of saying it's just in effect, this is all just ineffective. That would follow that the amount that was enjoyed by Avon, 15%, would not be treated as Avon's, because genuinely it is the income that has been produced by the personal efforts of the individual partner. So so that was our sort of fourth ground. And I think I can just move then. That was all I was proposing to say on section 850. Obviously, I haven't covered everything in our skeleton, but we rely on those additional points. So perhaps just for the short adjournment, I can say what's the consequences of that in the wider argument. I mean, if the revenue is right on the PIP appeals, then the consequence is that the profits in question are charged to income tax in the hands of the individual appellants according to their share of the profits as quantified. And if that's the correct analysis, the profits have been charged in the hands of all the partners, and that is section 850 doing its work. But if the analysis adopted by the FTT and the Upper Tribunal is right, and the true position is that the profits of the partnership are allocated to the companies, then one has to look at what happens next. Essentially, you say there are two stages now engaged for income tax purposes. There is an allocation of profits to the partners, including the corporate partner. The corporate partner is on this hypothesis recognised as the partner with the right to that share of the profits, and the individual partner does not have the right to that share of the profits. Something then happens when the corporate partner exercises its discretion to reallocate special capital to the individual partner. There is a further a step taken, and that further step puts the individual in the position of having money or money's worth in his hands. And we say that step, that transfer of value from special capital or haven to the individual, is in the nature of a payment of money and money's worth, and it is paid under an incentive reward scheme for the benefit of that individual, and it has all the hallmarks of income.
So we're now moving away from section 850.
Yes.
You're not saying that it retrospectively becomes the profit share taxable under section 850. We're now on to this is miscellaneous income.
Indeed, yeah. Just one point that was raised on this, which I think sort of goes to the heart of it. My learned friend said, "Well, look, it's just because this is a flaw because there's a disparity of rates between companies and individuals, and we wouldn't be taking this point if there was a transfer from one individual to another." And say, well, there would be circumstances where the partners could arrange to allocate profits to another partner, say with losses, another individual partner who's got significant losses, and that partner has allocated the profits. But in return, there's an agreement that that partner will pay us a regular sum of money to the individual. Well, of course, that's income. In the present case, if the senior partner, Mr. Platt, had sort of said to some partner, "Well, look, I really want your work here. I agree to pay you, £5 million a year for the next 2 years if you stay with the partnership." So he gets his partnership profits and he gets the £5 million a year from Mr. Platt. Say that's obviously income in the hands of the recipient partner. It's being paid to stay with the partnership. And whether Mr. Platt gets that 5 million from his post-tax profits or from other source, doesn't make any difference. This is a new arrangement that's been entered into. So what we'll have to address is does the fact that it's paid as a result of the exercise of discretion make any difference to that? And we say no, it doesn't.
But in broad terms, HMRC are supposed to be taxing the right amount in the right hands.
Yeah, and supposed to be taxing income. And when we look at the residual charge, section 687, that's its function, is to tax payments of an income nature which are not otherwise charged to tax. As we say, this so squarely falls in it. So we say the FTT and the Upper Tribunal are right. And I'll show you why we say they're right and deal briefly with my learned friend's submissions. But I will be quite brief on this.
Do you want to have a start for 5 minutes, or would you rather rise now and start again at 5 to 2?
If it's convenient for the court, then I think it would be convenient for me to take a break now, but I'm happy to.
All right, we'll break now and start again at 5 to 2.
All right.